Defense.
Thank you, Judge. Counsel? Good afternoon. Before you hear the instructions from Judge Kyle, and before you retire to deliberate on this likely most important decision of your lives, I want to make a few comments about, first, some legal aspects, and then I want to talk about life versus death. Mr. Hunter's done a fine job of explaining the law in this case and the aggravating circumstances that they seek to establish. And I promised you in my opening statement that I am not here to relitigate the guilt phase of this case. And I'm certainly not here to question your verdict. And I told you, and I mean it, that I respect that. What I want to seek to do is explore, or at least make sure in your minds that there's a clarification that you understand the law and the burden that's placed on the state in order for them to establish these factors. So it's got nothing to do with me questioning your verdict. I just want to make sure, we all need to make sure that you get it. As to the aggravating circumstance that this was committed for financial gain or pecuniary gain, you have to attach yourself to the belief beyond any doubt, based on your ability to reason, that what Curtis Wayne Wright, the 5-time convicted felon, told you is the honest truth. You have to be all in order for them to meet their burden to establish this aggravating factor. Like I said, we can't get inside your heads or your hearts or your souls. We don't know what went on in the deliberation room. We're not allowed to know. So we don't know how you reached your verdict and what conclusions were collectively made by the 12 of you who rendered that verdict. On a number of occasions, and many of you took copious notes, when I referred to my own, and as Judge Kyle has said many times, whatever I say isn't evidence, you rely on your own memories, your own recollections, your own notes. But on numerous occasions, Curtis Wayne Wright said, it wasn't about money, it was about children. This was about the kids for me, not the money. This wasn't a money thing. Now, of course, he also said it was a money thing. But like I said, we don't know, when you were reaching your verdicts, whether you were all in on the money thing and the fact that Dr. Sievers and Mark Sievers possessed life insurance, whether that, the mere existence of a couple having life insurance, persuaded you that therefore this had to be about the life insurance. We don't know. So I need you to clarify in your own minds whether you are all in on that theory, or if one or more of you instead thought that because they were lifelong best friends and that he feared perhaps that his wife might leave him, that this killing was done due to that factor. And if even one of you has a doubt as to how it actually went down, then you cannot find that this aggravating circumstance exists. So I'm not telling you what to think, I'm not questioning your thinking, but you gotta be sure
Judge,
that this is the way it went.
objection. May we approach?
Yes, sir.
Ready. The pecuniary gain portion goes to...
as to Mr. Sievers. Defense.
Thank you, Judge. So as I was saying, you have to be convinced beyond and to the exclusion of all reasonable doubt that Mr. Sievers' role in this was for financial gain and not for any other reason. Okay, so if even one of you has a doubt based on your ability to reason, this aggravating circumstance cannot be found to exist.
Judge, objection.
Sustained. It says to pecuniary gain, is to Mr. Sievers, and
The
You
doubt
may-
must be reasonable, Your Honor.
it must be reasonable. Yes, sir. You may continue.
Thank you, Judge. Now, as to the second aggravating circumstance proposed by the state in this case, the cold, calculated, and premeditated aggravating factor. As Mr. Hunter read the law to you, that there has to be a careful plan. That's right in the legal instructions. And this is difficult to talk about. Dr. Sievers is dead, and the tragedy is forever. But was there this careful plan? Curtis Wayne Wright, who is the state's star witness in the case, basically said that there was no set plan, that they drove all the way from Missouri to Bonita Springs, Florida, had absolutely no idea what was going to go down. There was several different ideas, he said, that they had, none of which involved Mr. Sievers, because there was no communication between anyone from June the 26th, 2015, until June the 29th of 2015. There was no careful planning going on during this period of time. And therefore no heightened premeditation, which, as Mr. Hunter correctly said in the law, is an even higher standard in this phase of the trial than it was in the first phase. Also in the instruction on cold, calculated, and premeditated is that let me read it all. A killing is premeditated if it occurs after the defendant consciously decides to kill. If the defendant, this is the state of Florida versus Mark Sievers, no one else. If the defendant, after the defendant consciously decides to kill, the decision must be present in the mind at the time of the killing. As I said, from June the 26th until June the 29th, there is no communication between any of these people in this trial. Therefore, how could Mr. Mark Sievers have in his mind at the time of the killing the design? He was in Connecticut. He had no idea what those two were up to. Now, that might sound like legalese or mumbo-jumbo or some lawyer talk, but it's the law. Judge Kyle's going to read you this law. You've all sworn to follow it. Whether you like it or not, Mr. Hunter said during the first phase, you have to follow the law. If you don't like it, when the trial's over, contact your representatives in Tallahassee, tell them to change it. But right now, this is the law. Now, I submit to you that neither aggravating circumstance has been proven beyond and to the exclusion of all reasonable doubt. But there is this list. If you find that one or both of them have been established, then you are going to go through this further process. And here's where we can kind of just throw away all the nitty-gritty. This comes down to life or death. This isn't the first time I've done something like this, a case like this. I know that some of you...
Objection as to what counsel knows.
Sustained.
I'll pass that.
Yes, sir.
Some jurors have their minds made up before prosecution and defense get up and make their closing arguments. They know in their hearts and their souls what their verdict is going to be. Doesn't really matter what we say. But as I said, this is a tragic killing. It's tragic for these folks. It's tragic for these folks. And that tragedy is never going away. But in the killing of Dr. Teresa Sievers, Mark Sievers is the only person who's facing the death penalty here. So when we talk about the mitigating circumstance that Mark Sievers has no significant history of prior criminal activity, and as Mr. Hunter conceded, he has no criminal history whatsoever. Never mind that it's significant, there's nothing there. You would have heard about it. So he's 51 years old, never been arrested in his life. Curtis Wayne Wright, who's a 5-time convicted felon, who wielded the hammer, one of the hammers, that killed Teresa Sievers. There was blood on the hammer, blood on his hands, blood on his conscience. He's going to serve 25 years in the Florida State Prison for physically carrying out the murder of a fellow human being. But yet the government wants you to render a verdict that Mark Sievers should die. And in any event, he's doing life in prison without ever getting out again. Consider that when you consider this mitigating factor. How much weight should be given to that? Judge is going to instruct you that even if you find that there are sufficient aggravators and those outweigh mitigating circumstances, the law neither compels nor requires you to determine that the defendant should be sentenced to death. And that's why Mr. Mummett mentioned several weeks ago, that's why you hold this power, this unique individual power to give life over death, regardless of any of these check things that you may do on that verdict form. Each and every one of you has that power. And you heard from his loved ones today. And you have to determine, through all the different things that they talked about in their relationships with Mr. Sievers, what a loving son he was, what a loving brother, circumstances of his childhood, divorce and broken home, being moved around, the relationships he's maintained with his sisters, the love from his mother and his stepmother, and the love he has returned to them, charity work he's done, his role as a father, which every witness, in fact several of the witnesses in the first phase, remarked on what a great father Mark is. The love he gave to his 2 daughters and the love they returned to him. Take some time. Look at some of these photos that we introduced when you go back to deliberate again. The love is obvious and it's apparent. And that will never die. That's forever. So I ask you to wield your power, that power of life over death, and I humbly ask you to return a verdict of life in prison without the possibility of parole. Thanks for your time.